In this video, I want to speak about clawback orders or agreements. And first of all, what is a clawback order or agreement? Broadly speaking, it is either a court order or an agreement between the parties. And the agreement could be a private agreement that is not part of a court order, or the agreement could be incorporated into a court order. The substance of the agreement or the order allows a party who produces material, principally in discovery, although you could have clawback orders or agreements in business transactions, but it arises principally in discovery, to obtain back from the recipient party a document or other material that is claimed to be subject to attorney-client privilege or work product or other protective order. What is the general law that applies with regard to obtaining back such material in the absence of a clawback order or agreement? And here there would be differences between state law and federal law. In most states, unless they have adopted a rule similar to Rule 502 of the Federal Rules of Evidence, common law decisions have dealt with the question of when a waiver of attorney-client privilege or work product can occur by production of the material. And broadly speaking, the approaches of the courts fall into three categories. One approach is a pure waiver approach. And under this approach, if material has been produced that is subject to a claim of confidentiality of attorney-client privilege or work product, the production of the material results in a loss of that protection because, so to speak, the cat is out of the bag. That is, it's too late to maintain confidentiality when the material has been produced. Now let me say, there is a distinction drawn by some courts between work product and attorney-client privilege material, because the essence of work product is not so much the confidentiality of the material as it is the fact that it is prepared in anticipation of litigation. So some courts follow a different standard for work product and look to see whether or not the material has been exposed to the adversary. If that's the case, then work product has been lost. But of course, in many discovery cases, that's exactly the person to whom it would be exposed. So even under this different standard for work product, under the pure waiver approach, there would be a loss of attorney-client privilege or work product protection. A second approach, again in the absence of a court rule, is the approach of looking to the client's intent. And under this approach, the question is, did the client intend to voluntarily waive the privilege or work product protection? If there was no such intent, if it wasn't done intentionally, then there is no waiver. Obviously, the waiver approach and the intent approach are poles apart. The intent approach is much more protective of the client. The waiver approach is much more protective of the interest of the opposing party and is based upon the view that if there has been an exposure of the material, there is no longer an expectation of confidentiality. The third approach, and I would say the more modern approach, is a facts and circumstances approach, which looks at the precautions taken, the extent of the disclosure, the significance of the material, and other factors to decide whether or not a waiver has taken place. So in the absence of a court rule, if material has been produced, a court would look at these various factors. Now in the federal courts, we have Rule 502A, which was adopted as a rule of evidence several years ago in the federal courts, and in some states you may have an equivalent state court rule. And under Rule 502A, you will have a waiver of the material when it has been produced if certain requirements are met. First of all, you would look to see whether or not there was an inadvertent production of the material. Secondly, you would look to see whether appropriate precautions were taken before the material was produced. And thirdly, you would look to see whether reasonable steps were taken after learning of the production of the material to obtain the material back. And if all of those requirements are met, then there is no waiver of the material by production of it. If any one of those is not met, if the production was not inadvertent, if the production was not taken after reasonable precautions, if prompt remedial action was not taken, then a waiver would occur. A well-drafted clawback agreement can deal with a number of the issues involving inadvertent production. So, for example, in a jurisdiction which doesn't have the equivalent of Rule 502 of the Federal Rules of Evidence, so in state court where there is no such rule, a clawback agreement could avoid the problems of a very restrictive approach of the courts to the concept of protection of the material. So, for example, in a jurisdiction which follows the strict waiver approach, where there is any production of the material, there is a waiver, a clawback agreement could allow the material to be obtained back, even though the court decisions in that jurisdiction were not favorable to obtaining the material back. Now, in such a jurisdiction, if there are such court decisions, a prudent lawyer would have the clawback agreement incorporated into a court order in order to avoid the argument that the agreement is unenforceable because of the existing case law in the jurisdiction. What about in the federal courts, where we have Federal Rule of Evidence 502, which provides for standards for preventing a waiver? Even here, the clawback agreement or order can be very important for a number of reasons. First of all, the rule itself is unclear in a number of respects. When is a waiver or when is production of material inadvertent? Some court decisions have said that if there is any lawyer participation in the production of the material, it can't be inadvertent. If the lawyer participated in reviewing the material, then perhaps the lawyer made a mistake, but that's not an inadvertent production, it's a mistake of a lawyer. And ironically, if the lawyer didn't participate in the review of the material, the consequence may still be a waiver, because under Rule 502, if there were not adequate steps taken to prevent the production of privileged material, that in itself can be a waiver. It's also unclear under the rule what are adequate steps. It's also unclear under the rule what prompt remedial action is required, and the rule does not specify the obligations of the recipient party with regard to material that may be subject to a claim of waiver. So a well-drafted clawback agreement can provide a lot of flesh to the federal rule, and can in some respects replace the federal rule. So there are court decisions to the effect that if the clawback agreement or order specifies that it replaces the federal rule, then the standards of the order or the agreement would govern. And just to take one example, the clawback order or agreement could specify that material may be returned and obtained back even if the production was intentional and not inadvertent. And the clawback order or agreement could specify the precautionary steps that could be taken in order to avoid a waiver. And this ties in with the emerging law dealing with technology-assisted review, or TAR. There is a body of case law developing which allows lawyers in connection with discovery to use technology-assisted review. That can be related to clawback orders, because a clawback order could specify that if the lawyer complies with certain standards of technologically assisted review, that the production of the material in compliance with those standards will not be treated as a waiver of the attorney-client privilege or work product protection. So, the well-drafted clawback order can provide great protection to lawyers operating in state court where there is no governing standard other than the common law decision, or in federal court where Rule 502 of the Federal Rules of Evidence applies, but where Federal Rule 502 leaves open a number of issues that could be clarified through an order or an agreement. I've written an article in the South Carolina Law Review, which will be coming out shortly, which deals with various problems with clawback orders and agreements and provides suggestions to lawyers on how to draft them. So I encourage you to take a look at that article if you're interested in this topic, and if you want to get a copy of the article within the next few months before it is published, I'd be happy to send you one. You can reach me at my law firm, which is Crystal and Giannoni-Crystal. Our website is www.cgcfirm.com, or you can email me at nmcrystal, Crystal, @cgcfirm.com.